Good afternoon. The Senate Judiciary and Public Safety Committee will come to order. Today's Monday, February 24, 2025, and we do have a quorum present. We have one item on the agenda today, Senate File 856. Senator Gustafson, why don't you come on forward? I understand Senator Kroon's going to join you to present the bill. And when you two are ready, you can begin your presentation. Members, I will call your attention. There is an A19 amendment in the packet and some other materials for your review as well. Senator Gustafson.
Thank you, Senator Latz. Chair, members of the committee, thank you for the opportunity to present SF 856. The bill establishes an independent office of the Inspector General to strengthen accountability, transparency, and oversight across state government. Minnesotans deserve to know that their tax dollars are being used efficiently and ethically. The legislation ensures a centralized independent office to investigate fraud and abuse, separate from executive agencies to enhance public trust and government integrity. By consolidating investigative functions under a single nonpartisan entity, we create a more effective oversight structure that is accountable to the public. The bill sets clear qualifications for the Inspector General, ensures professional standards, and provides strong safeguards for whistleblowers. I want to thank Senator Kroon for being an active co-author on this bill, his work on this bill, and his help in drafting the language, and for being a co-presenter today. I also want to thank Senator Latz, another co-author, for his help and input on this bill as well. In addition to these judiciary members, I want to thank Senator Draheim and Senator Putnam, our other co-authors, as well as the House authors who join us each week for a bicameral, bipartisan meeting to come together on common language. This truly is a bipartisan effort that we hope will send a message to Minnesotans that we share their concerns about misuse of tax dollars. I look forward to the committee's discussion. Happy to answer questions, and if it's okay with you, Chair, I believe Senator Kroon is also going to present.
Senator Kroon.
Thank you, Mr. Chair, members of the committee. Thank you for the opportunity to present the Office of Inspector General bill, along with Senator Gustafson. Thank you for Senator Gustafson for bringing this bill forward and for all of the work that has been done to truly make this a bipartisan effort. I will limit my comments to a couple of different areas that are reflected in the A19 that is in your packet. We worked hard with the BCA to address the main issue that's in the letter from the Commissioner of Public Safety, regarding the licensed peace officers being part of this office. We took that out, which goes to show how we've been working with the various stakeholders here to come up with a workable product and a legal and constitutional product as well. The other thing I'll mention is there's been a lot of work done with respect to the Data Practices Act, and we're open to committee discussion on some of these issues that you're going to hear from some of the testifiers. A lot of work's been done in this area, and some of the language that we've put in here is out of abundance of caution, because we're very cognizant of the fact that there isn't an established office in existence to kind of be part of the negotiations when it comes to these data practices issues. And so we'll hear from some testifiers with some issues here. And I just wanted to say we're open to a committee discussion on some of these issues and any changes that the committee sees fit on the Data Practices Act. And so with that, again, I'd just like to thank Senator Gustafson again for her efforts on this bill, and I look forward to a good discussion.
So members, in your packet, there is a bill summary, which is now out of date, but it's from state and local government at the time the bill was being considered there. There's also a letter to you from the Commissioner of Public Safety for your review in the packets. Would the next step, Senator Gustafson or Senator Kroon, then to be consider the A19 amendment? Is that your intent?
Yes, Mr. Chair.
Okay. Why don't you go ahead and describe the amendment, the content of it, and then we'll have it offered.
Thank you. So lines 1.2 and 1.3 make the OIG subject to judicial authority. Line 1.4 through 1.5 changes the definition of fraud. 1.6 to 1.8 changes the definition of waste. Lines 1.9 through 110 clarify that the BCA and the AG are authorities to which the IG can refer matters for civil, criminal, or administrative actions as appropriate. Lines 1.11, technical correction. 1.12 through 3.3 replaces the data practices provisions. Lines 3.4 through 3.9 eliminate the requirement to employ peace officers and replaces it with requirements to employ experienced investigators with the OIG's discretion. Lines 3.10 delete the requirement for the OIG to redact sensitive or confidential info. Line 3.12 through 3.20 clarifies the role of the Legislative IG Advisory Commission. And lines 3.22 through 3.25 excludes employees or positions in the Department of Corrections from being transferred into the new agency.
Senator Gustafson, could you give me a little more detail on line 3.10, what's being deleted there? Page 7, delete lines 12 and 13.
Sorry, I'm just having a moment to find it. Apologies. Thank you, Mr. Chair. I believe this was part of the data practices conversations that we were having with Minkoji. As far as I know, those were, this is the reason why behind it. It was to preserve some of the investigative data. Maybe I could answer if there's anything further on it that you are looking for that I could answer.
Well, all right, we'll ask Senate Counsel to assist us here, Ms. Primo, and then we can have either Senator Crooner or Mr. Hailing come forward if he was involved in this as well. Ms. Primo.
Mr. Chair and members, this was done somewhat as a technical or conforming change. The terms used in this specific subdivision, like sensitive or confidential, aren't necessarily the way that we use those terms or those words within the data practices framework. And so this was deleted, and instead this idea or concept is captured in the new section 8.
Thank you. I'm satisfied. Anyone else have any questions about that topic while we're on it? All right. And then also Senator Gustafson or whomever can answer, could you please give me a clarification on the change in the definition of fraud? That was on
Thank you,
the
Mr. Chair.
line 1.4.5.
Yes, thank you, Mr. Chair. That was a product of another bill that was moving through state local gov on a whistleblower act. The definitions of fraud and abuse on that bill were different from the ones that were in ours. So in the practice of trying to make some of these fraud bills that are passing through uniform, we came together with counsel to come up with the definition that addressed both our end goal and as well as the whistleblower bill.
Senator Gustafson, that's in response to a conversation we had in this committee last time the bill was brought up. I recall some conversation there. So now it will read, fraud means an intentional or deceptive act to gain an unlawful benefit. Is that correct?
Mr. Chair, that's correct.
Okay, and then could someone walk us through the data practices, Section 8? Which one of you wants to take that on? Senator Caroon?
I will give it a shot, Mr. Chair, thank you. I would say a lot of these changes were between discussions between the authors, Senate Counsel, Minkoji, and Rich Newmeister. The idea here was to set up a system that was similar to how some of this works in other cases. The technical aspects of some of the changes, I'm probably not as proficient to walk through as Senate Counsel would be. The goal from our perspective was to come up with a workable plan that has basis in other statutes and to get as close to possible as we can with Minkoji, Mr. Newmeister, to be as transparent as possible. I think we got close. There is still a couple sticking points that I'm sure they're going to be testifying on. But if you want like more of a walkthrough there, I'd probably have to defer to Senate Counsel to kind of go through that.
Ms. Primo?
Mr. Chair and members, the data practices language begins on the A19, page 1, line 13. It uses the definitions from the Data Practices Act, and it states that the Inspector General is a government entity within the meaning of the Government Data Practices Act and is subject to Chapter 13. It permits access to data of any classification that's held with another government entity, and also states that it is not a violation of Chapter 13 if another government entity releases that data pursuant to a lawfully executed subpoena under this chapter.
Ms. Primo? On that point, does the data then that the Inspector General gets, does it carry the classification over to them, or does it change in its nature when the Inspector General gets it?
Mr. Chair, under Chapter 13, unless there's a more restrictive classification here in this statute, it would carry that data provision that's applied at the disseminating entity.
Okay, so the Inspector General would have access to it, but it would otherwise remain in whatever its classification was throughout the duration of the Inspector General's involvement, or is there a change that might happen at any point?
Mr. Chair, there are some changes specifically within Subdivision 5 in terms of when the investigation is active versus not, and when that classification that's from the originating entity applies. I can walk through that, and hopefully that'll answer your question.
Thank you. Please go ahead.
So turning to page 2, Subdivision 4 at the very top, the Inspector General also has the authority to disseminate data of any classification to a government entity or a law enforcement or prosecuting authority under certain standards. Subdivision 5 is the specific subdivision which classifies the data. It states that while the investigation is active, the data are confidential or protected non-public. When the Inspector General completes the investigation, the data becomes public, except if the data would jeopardize, if the release of the data would jeopardize another active investigation, if the OIG reasonably believes the data will be used in litigation, or if the data is classified as not public under another statute, so that traveling classification, or is classified under paragraph E of this amendment, which protects the identities of complainants or whistleblowers.
So, Ms. Primo, what about confidential data on individuals? So you've got the non-public data remains non-public. Whistleblower identity is protected, but what about data that comes over as confidential? Does that become public when the investigation is complete?
If the data was classified at the originating entity as confidential, it would remain so under this under the statute, under the traveling data classification.
Even after an investigation is complete?
Well, yes, even after an investigation is complete, if it was classified as not public under another statute. Those provisions tend to be rare, and so I'm trying to think of a situation where that would apply. Because in other entities, typically that's for active investigation. So if let's say there are two entities investigating and they send over some data and there's still an active investigation going on at the originating entity and that's classified as confidential, that I believe would remain confidential under this statute.
So in line 2.14 where it says not public, that's encompassing both protected non-public data and confidential data on individuals?
Yes, Mr. Chair, looking back on page 1, the definition of not public data has the meaning given in chapter 13, and that term, not public data, includes all 4 of those privacy classifications.
Thank you. Please proceed.
Let's see. So I think we're on perhaps line 2.15 now, where the data that's reasonably used in litigation remains confidential or not protected non-public until that litigation is completed or no longer being actively pursued. And then in paragraph D, this is about when the Inspector General makes a decision to no longer actively pursue an investigation, but they have not completed it. That data remains private or non-public except for the specific data listed in clauses 1 and 2, which become public. And this specific language, as well as a lot of provisions here, are modeled after the OLA statute. And even when that data when the investigation is no longer active, the data about individuals or entities that are not government entities remain private as well. And paragraph E classifies data on complainants or whistleblowers as private data if certain standards are met. And the final paragraph on the data practices provisions at the top of page 3 provides that non-government entities data from non-government entities are treated the same as if they are from a government entity.
That last provision actually would end up probably giving it more protection than it otherwise would have. Is that correct? Ms. Primo?
Mr. Chair and members, yes, possibly that provision is included in the OLA statute as well.
Before we move on to testifiers on the data practices provision, do any members of the committee have any questions for Ms. Primo? All right, we have a couple of people have signed up to testify. I assume it's in connection with the data practices provisions, but certainly more of it as well. We have Rich Neumeister and Matt Ealing, whichever one of you wants to begin with. I've got Mr. Neumeister on our agenda first, but it doesn't matter to me. Mr. Ealing, come on forward. Go ahead and state your name and give your affiliation and spell out the acronym, if you will, so we know exactly what it means.
Thank you, Mr. Chairman. Matt Ealing, Minnesotans for Open Government. Our previous acronym was too wieldy after 30 years, so we changed it.
So now what's it called?
Minnesotans for Open Government.
MNOG or MOG?
Yeah, MNOG sounds better than MOG, we think.
Okay.
So that's, but it could be a work in progress.
Your organization, so you get to decide what we call it, at least publicly, right? So it's no longer MinCoG.
No longer MinCoG.
Okay, we'll just try to be respectful and get the name right.
Thank you, Mr.
Go
Chairman.
ahead, Mr. Ely.
We continue to be an all-volunteer, nonpartisan, nonprofit organization focused on government data access issues. And I'd like to open by commending the authors for their bipartisan work on this bill and their attention to the data issues that involves. One of the consistent messages we've brought here to the legislature over the years of coming up here as volunteers is the importance of bipartisan attention to data access issues, and so it's great to see that kind of work being done here today. We've just looked through the amendment that's been described. In general, we think this is going in the right direction. There's one area that we'd like to talk about a little bit that could use some further attention. I'll talk briefly about the guide path of investigative data generally under Minnesota law. So whether it's in a criminal or a civil context, generally the guide path has been not public classification applies during the active investigative phase. This was also the case with the OLA's provision in 3.979, I believe. And then in the civil and criminal context, the glide path is once the active phase is done, then there's a general public presumption that takes effect for the most part. There's some, each statute, 1339 and 1382, have some provisions that would allow certain pieces of data to remain not public, but a public presumption then takes effect. And under the OLA statute, when an investigation is closed, they've finished the investigation, they've come to a conclusion, that is still the case. In here, there's a provision that is brought over from the OLA statute 2.18 to 2.25, brought over in concept, and that was changed a couple of years ago. We talked with the legislative auditor extensively about it. We had a respectful disagreement. We came to somewhat of an accommodation, but we don't feel that it's an appropriate accommodation to carry on to an entity that has investigative functions like these. We would like to see the guide path continue to be not public during the active phase and then generally public during the inactive phase. And the difference in starting on 2.18 is that if the OIG decides to abandon an investigation, not complete it, then you're going to have a much more restrictive classification take effect. So you won't necessarily get to see all of the investigative data. And I'll tell you why that's important. So I individually and through another organization do a lot of data requests and FOIA requests. For instance, I requested all of the FBI files of Marv Davidoff, who is now deceased. He was an active peace protester here in the Minnesota region for many, many years, and was curious to see what the FBI was doing in regard to investigating him individually. He was never prosecuted that I was aware of, so there was active investigative activity going on. And this kind of investigative activity is a very powerful function of government. So even if the government is investigating, stops investigating, I think that there's still a public interest in seeing what they were doing when they terminated the investigation. And if you look through Mr. Davidoff's files, there's all kinds of innuendo and sort of scurrilous information being gathered up about him that just simply wasn't true as far as I could determine. And so you get through that FOIA request process, you get an insight into what was going on even when the investigation itself was not completed. And so I think that needs to be considered in terms of the data classification that applies to these non-completed OIG investigations. So that's the major issue that we see for some future work.
Mr. Illing, what about data that comes over to the OIG as not public, part of an investigation? What would be your position on the classification that data should carry after an investigation is closed?
Thank you, Mr. Chairman. We feel confident that that's taken care of by a couple provisions of the general closed investigative section here. So if you look at 2.12, 2.13, 2.14, and specifically 2.14, if there was a more restrictive classification to the data at the originating entity and it comes to the OIG, even in the completed investigative phase that is public, that would be an exception. So we feel confident that that would be an exception that we're willing to live with.
Okay. Senator Limmer.
Thank you, Mr. Chairman. As I'm listening to Mr. Ealing, I couldn't help but recall the investigations that happened in the Minnesota Department of Human Rights. they too investigate violations of civil rights on individuals on behalf of citizens. And when they conduct an investigation, they keep the investigation rather confidential until there's a finding. I don't recall entirely, but I thought that they would keep that investigation sealed in the event that they did not find, or they did not arrive at a finding, or if there was not enough evidence to continue the investigation. I don't, maybe counsel could recall, but I don't believe they open their files in the event that they do not discover a finding of probable guilt. And so, and I know they do that in order to protect the party involved. An accusation, an investigation that could become public, just the investigation, not a conviction or a finding of fact, could be as damaging as a conviction itself. And so, Mr. Ealing, why would that practice in the Department of Human Rights be different than what this possibility could find?
Senator Limmer.
Mr. Ealing.
Mr. Chairman. Thank you. To my recollection, you are absolutely correct that there is a more restrictive classification, and I have not looked at that statute in a while, so the particulars escape me. But they do have a more restrictive investigative outcome classification than in the 1339 or the 1382 context. That's one area where also we have a disagreement with how that was handled back in the day when it was passed. We think that there should be more information available about the conclusion of those sorts of investigations. Particularly if you look at the Human Rights Department context and some of the things that they've been asked to investigate, some of the data they've been asked to compile within recent years, and I know there's been a discussion and debate over, are they compiling dossiers of information on protected speech within the Department of Human Rights? So to the extent that a public classification of some kind at the terminated investigative stage or the abandoned investigative stage would help to illuminate some of those issues, that's, again, one of the reasons we would like to see a little more sunshine in this abandoned investigative phase within the OIG context.
So, Mr. Chair, Mr. Ealing, so just a finding of not guilty or not enough evidence to pursue would be not enough for your organization to be satisfied with the public record. You would rather want to know the little tidbits of information or perhaps a whole file? Where do you parse the elements of what you think the public should know versus what could be damaging to perhaps an innocent party?
Mr. Ealing.
Mr. Chairman, Senator Limmer, let me give you before I answer you in full, I'm going to give you just an example of a piece of information that's classified by the way this is written to kind of illuminate these issues. So if you look at lines 2.24 and 2.25, there's a general private data on individuals or non-public classification, non-public classifications of data on not individuals for entities that are not government entities in that abandoned investigative data context. So for instance, a nonprofit organization that was investigated, even the existence that there was an investigation of that nonprofit would not be public under this particular language. So that's one of the places to start to think about even the not, particularly because there are so many issues with contracted government functions these days, that's a place to start thinking about, should at least the name of the entity or the individual be public? Because in this case, it's not if they're not a government entity. then you can build backwards to the layers of information that should be perhaps public. What were the allegations? You certainly have disposition is public here, existence and status, but there's not something pertaining to allegations as far as I can tell. So I think we could at least take a couple steps back to get more information, more sunlight on this, if people are uncomfortable with going with the full investigative file at the abandoned stage.
Any follow-up, Senator Limmer?
Well, Mr. Chair, not exactly, but I think this discussion is going in the direction of finding balance. Balance is a key element to any data privacy statute that we write. And I think this discussion, I don't have anything exact to make reference to in the existing bill before us, but I do think that our discussion is going in the direction of where is the balance to satisfy the public informative good versus the protection of an individual. We're trying to find that balance. And perhaps lines 24 and 25 on page 2 might be an element that we may have to discuss a little bit more detail. But it always gets this way when we discuss data privacy issues, is finding that balance, which is critical to how we react.
Mr. Earling, can you help me understand the difference between paragraph B in subdivision 5 on line 2.10 and paragraph D on 2.18? As I'm gathering then from our conversation, paragraph B relates to completed investigations, and paragraph D relates to abandoned investigations or no longer actively pursued investigations. Can you help me understand what the difference would be and why there's a distinction?
Thank you, Mr. Chairman. You are absolutely correct about that is the distinction between those two paragraphs. And I'll just wind this discussion back to the discussion we had with OLA when their statute was changed a couple of years ago. So under the previous iteration of the 3.979 language, upon the basically the end of the investigative activity, there was going to be a public pass-through or a change in classification to a public status with a couple of things that were still classified as not public. But generally, no matter if the OLA had either completed the investigation, published a report, or if they ceased the investigation, then they reverted to a more public status at the end of the investigation. And so, Ms. Randall, the legislative auditor, can certainly give you more history about their thinking about why they made this change. Again, we thought it was too restrictive because at the abandoned stage, you lose a lot of information about what was happening that we thought was informative to the public. So that's the distinction. That's part of the history about why it happened. I don't want to speak for the legislative auditor about their rationale for why they changed it, but that's the procedure that happened a couple years ago.
Senator Limmer.
On this subject matter, Mr. Chairman, I noticed that in the reference on 210 and 218, or the paragraph starting on those respective lines, how would the public know, according to this writing, that a completion of the investigation was actually completed versus how would the public know if it's no longer being pursued? There should be some announcement from the Inspector General in this case to make sure that the public knows how it ended its investigation. One way it's completed, or the other way it would be no longer pursued. I think that would be important for the public to know as well. I don't, unless I'm missing it, I don't see any announcement required by the Inspector General in this case.
Mr. Earling.
Mr. Chairman, Senator Limmer, you certainly could put in some kind of prescriptive language announcing that change or that termination. The termination itself would be public data, even under the existing language of this amendment. As I read this, if you look at lines 2.22, even in the abandoned phase of investigation, there is some public data, including the status of that investigation. And so the fact that it becomes terminated without resolution would be public.
Prescriptive announcement, if it's available, and somebody can put in a request to get the status, I think that's probably good enough.
I mean, honestly, like, do any other entities do that, or they make an announcement? I don't think they do. And then just leave that up to the OIG.
Right, so if someone wants to figure out what's the status, they could get the status, but they'd have to make a request.
So I'm just curious, is there anyone here from the Office of the Legislative Auditor that can shed some light on why the distinction? And, I mean, I'm a little bit concerned that you could have an indefinite, inactive investigation without any closure one way or the other. Just kind of putting it on ice and then it sits there forever, retaining its extra private or not public status. Go ahead and identify yourself.
Thank you, Mr. Chair. Members, for the record, my name is Judy Randall, Legislative Auditor. Thanks for asking the question. I think some of the difference, and in our language, it's about audits as opposed to investigations. We take in an enormous amount of requests, complaints, allegations. And this is something that has changed over the last even just 5 years. So prior to making this change in the law, most of what we received, we looked into, and we conducted an audit. We now receive literally hundreds of allegations, complaints, concerns. And so we cannot do full audits on them. But what we do is a preliminary inquiry to gather a little bit of information at first. And then we decide whether or not to conduct a full audit or not. And so there are a lot of times where we put these on a pending list, honestly. So we're like, oh, this is important, we need to look at it, but it's not our top priority because we have a total of 4 people handling all of this that comes through. And so it can be quite a while before we get to it. And then when we get back to it, we will look and see if it needs to be actually audited. So during that time, it's not that we're not going to do it ever, but that it is kind of being pended until we have resources. There are other times that we receive something and we do a little bit of work and we immediately decide this is not in our jurisdiction, this is not something that we can prioritize right now, or et cetera. And we close those, but we haven't conducted a full audit. And so all we really have in those cases, and this is the vast majority of cases, is we have an allegation that we haven't vetted, that we can't say whether it is a fair allegation or not. And it's kind of to what Senator Limmer was talking about with the concerns related to the Department of Human Rights, and that there are serious allegations being made that name people that we can't dedicate the resources to determine if those are fair or not. And so we are concerned about protecting those people. In essence, we almost have like a database of allegations and complaints that aren't vetted. And so in those cases, we think it is, back to that balance question, that it is prudent to balance the rights of those individuals that we haven't been able to vet, we haven't interviewed, we haven't done the necessary work to see if it's a legitimate concern, to protect their information and their names. And so that is the cases where we have requested that the information that is public be limited to, an existence of an allegation, the status, and then any work that we have done. So if we have done work, if we've interviewed people, if we've, pulled together information, that work then becomes public, unless it contains other information that is classified elsewhere as not public. So I don't know if that helped, but there is a large number of allegations that we can't get into, and we think it's not prudent to make those allegations public.
So, Ms. Randall, I appreciate that explanation. So I suppose it could be any point along a continuum at which stage you decide we don't have the resources, or there's not enough here to continue, but it's not fair to make this public, even though we're pausing for now. I mean, the language in the amendment says no longer actively pursue an investigation, would suggest that at some point it was actively pursued, is for the proposed Office of Inspector General. Which sounds a little bit more like we've done some vetting, we've done some serious analysis and investigation. We don't have enough right now to reach a conclusion, so we're going to pause it indefinitely without reaching a conclusion, as opposed to these are merely allegations and complaints. We don't have time to look into it now or anything more than a brief review. And we're going to set it aside in the event that we have resources down the road or something frees up. And I'm not quite sure how you write the language to capture all of these various points along a continuum. We're putting all this theoretically in our heads, right? But in terms of any specific allegation, at some point, you see what you've got, and you say there's not enough here to devote the resources we have any further. And then what do you do with the information, right? Am I capturing this correctly, Ms. Randall?
Thank you, Mr. Chair. Yeah, I think you are capturing it very well. I would say at OLA, we don't, once we allocate resources, we go to conclusion. So, other than kind of the very high level, like look at it, make a not quick, but a relatively quick decision. Once we start to, quote, actively pursue something, we under my experience at least, we have not paused and not issued a final report. I will say I was not involved in drafting the OIG language. I know they pulled from our statute, but so I can't speak to how it directly applies to the OIG. But I would think usually once you've invested enough resources, you're going to go to conclusion. Oftentimes a report that ends in no findings it's also a valuable report. And so we like to publish those as well.
Okay, so I do have the OLA's statute. It says no longer actively pursue an audit without the release of a final audit report. So it could be all the way up to the point of a decision we can't reach a conclusion here, or sounds like your practice is if you're going to go that far down the road, you're going to reach a conclusion that there is or there is not violation A, B, C, or D.
Mr. Chair, that's correct.
Ms. Randall, okay. But I assume then it sounds like that would also include, in practice, those initial intakes and cursory reviews that are set aside and not actively investigated further. Ms. Randall?
Mr. Chair, in those cases, though, we don't publish a final report. So then the information that is public is the existence, status, disposition. And so again, we don't provide that underlying information in an interest of protecting the person who is alleged to have done something.
Okay. Well, this is helpful, and like Senator Limmer, we're all balancing this as well. You know, once information gets out there, allegations, even in a social media posting, I mean, everyone in the world is drawing their conclusions. And so there's some value to not having that being made public, and then people's imaginations can go wherever they want to go. While Ms. Randall's at the table, any members of the committee have any follow-up questions to those, to the testimony? Thank you, Ms. Randall. Mr. Newmeister, did you wish to testify as well?
Mr. Chairman, members of the committee, my name is Rich Newmeister. I am guided by several principles in my testimony. I want to enhance transparency, as I call sunshine and accountability, deterrence of future misconduct, learning and improvement through public scrutiny, building public trust and credibility, and fulfilling legal and ethical obligations. These are 5 principles that's guiding me in my testimony on a new scheme that Minnesota is going to do, the Inspector General, which a number of states have done. I think it's important with data policy, data practices type language, there is no ambiguity. It's clear and concise as to what is public and to what is not. And that's what I'll be addressing with you today. First of all, there are basically 3 concepts of pot of data that there will be in terms of investigations, using the term broadly. There will be the investigation that will look at policy changes, fundamental administrative changes, or whatever. Then there's the civil investigative, and then there's the criminal element of that. To me, it's not clear in statute that says who is going to determine of the path of those 3 kinds of investigations. So if you can put something in there, that it will be the Inspector General who will determine the way it goes. That helps for policymakers and for the public to what to expect. Number 2, sunshine, sunshine, sunshine is important in these elements. In my survey of what other OIGs have done, it's all over the map. You have OIGs that will put out information, let's say on that pot of data that we were just talking about, Mr. Chairman, in regards to allegations, but it doesn't go either to a civil, it doesn't go to a criminal, and it does not go to making changes in the way the entity does. But what will be public is the nature of the allegation and who it was against, naming at least people that are not individuals. But if it was with a nonprofit, if it was with an agency or whatever, that is generally public. So it talks a little bit about that pot data, and I'll refer to that in a moment. Now, if the determination by the Inspector General, if the data is criminal of nature, it will go to 1382, and it's very clear. There's a whole scheme of that. So eventually, the public will know more. If it goes the route of the civil investigative way, with a county attorney or whatever, then eventually under 1339, it becomes public, except for one area. So as you know, Mr. Chairman and members of the committee, we discussed the energy policy advocates language. So let's say if the IG refers a civil investigative matter over to the AG, and then it goes through the process, that data, because of that decision under 1339, for county attorneys and all, or city attorneys who may do a similar civil investigative, that would not be public. So if you're going to have the bill go forward, and it appears that most of these referrals for civil investigation and civil action will be with the AG, I think the public deserves, at least in that specific realm, they go back to the regular routine of inactive investigative data. The third part, and this is when you take a look at the amendment, particularly lines through 218 through 225. Mr. Chairman, as I have learned over my decades here, it's always important to know history and why things came about and why we're dealing with talking about the legislative auditor language now. 2 years ago, the legislative auditor initiated a change in its data practices statutes. Generally, the type of data that was being discussed a few moments ago would eventually become public in the broad scheme. At that time, the OLA decided to do the bill, which was talked about. That language never came before this committee or the equivalent of this committee in the House for data practices. It was buzzsawed in the government whatever it was called but 2 years ago, the government operations. And that's where Minnesotans for Open Government and myself had a very strong tit-for-tat discussion with the legislative auditor and also with other people in that regards. So I think it's important to know that history. I do think that the public is outcrying for more public data to be available. So in those situations where it does not go any further, it's not referred out to civil or investigative, but also it's just that, hey, there was an allegation. I think the language in 218 to 225 can be expanded a little bit more for more sunshine. Look at what some of the other states have done. And if the bill's going to go forward and if the authors, the legislators who are being co-authors of this are willing to work, which they all have been, and I thank them for a number of days. Myself and Matt have shared a lot of back and forth, and I've appreciated that, so that some of these issues can be dealt with before the committee. So, Mr. Chairman, members of the committee, I think there can be some more accountability and sunshine and some more information to be public. Then I just asked the rhetorical question because I'd like to see it on record. My impression would be that if any data as a referral out that goes to a criminal investigation or for civil investigative data, that it will take the regular route. So that what we would expect, if the IG says to the BCA, hey, we got some trouble here, we want you to do an investigation. So if the investigation happens, it goes to 1382 route. If it's with civil investigative and referred to like the AG, it goes to 1339 route. So the public in the end gets sunshine. That's not mine. And finally, Mr. Chairman, there's a difference between not public data and secrecy. Over the years, I've seen where private, confidential, not public data, non-public, whatever, be used in a realm for secrecy rather than accountability and sunshine. And that's how I'm viewing the bill and why I've worked hard and I've appreciated the work of your council and folks. And we'll just go from here. And I'm open to any questions.
Mr. Newmeister, how would you propose to change this portion of the amendment if your vision were to be
In a general
reduced to
way,
writing?
Mr. Chairman, data relating to the investigation's existence, if it was an agency, the nature of it. So if the public found out, for example, DHS had allegations of corruption or allegations of malfeasance or money being spent, at least the public knows that. At least the public will know that it was looked at and it was untrue. That's, Mr. Chairman, you made reference to the social media thing. Yes, things get spurged over the social media. But also, Mr. Chairman, it's important for the public to know that things are being investigated and that we do know what the general nature of things are, rather than hide. Currently, my experience has been in interaction with the Health and Human Services temporary IG. I don't know if they've appointed one. Reporters were asking for just this, what were they being investigated about? You know, what were they investigating for, and the cases were inactive. They weren't being told. They're just being told, well, 21 are being investigated, some are closed, but there was no type of data to be, why, how come? What was the nature? Was it with a social agency? And I do see the difference between an individual and an entity. So that's generally my, you know, there can be some more working on that, but I don't have some of the examples I've seen what other states have done in front of me right now.
Well, Mr. Newmeister, you're looking at line 2.22, right?
Yes,
And after the existence, you just suggested language to the effect of the nature of the investigation.
nature.
Or data relating to the investigation's existence, nature, status, and disposition. But you also included in your comment that it was untrue, which sounds like a conclusion about having completed an investigation and drawn a conclusion about the nature of the allegations, not just stating the nature. Was that an inadvertent addition, or
Well,
do you,
Mr.
because they're not getting to that point
No,
when
we
they're
haven't.
pausing an active investigation?
Mr. Chairman, you're right, we haven't gotten to that point, but I would think that if it's not going any further, that I would believe that unless there's resource issues, that they have determined that the allegation was not true.
Well, then
Or
that would be
maybe they
a,
didn't have the evidence enough.
but then wouldn't that essentially be a closed investigation? You've reached a conclusion that the allegations are not true, or we've reached a conclusion that we're not going to investigate any further because we don't have the resources, therefore we're closing it?
Mr. Chairman, that could be one of two dynamics
Yeah.
that they may decide to close. And if they close an investigation without it being referred out to criminal or civil, that would be not public here, even currently.
Right.
I would like to see that public if they came to a conclusion, hey, there's no evidence here to say that this allegation is true. There's two possibilities of how the pot of data can determine something. Hey, there's nothing here, or number two, we've done something, now it's.
But, so, Mr. Newmeister, in example A, they've reached a conclusion that there's not enough here to decide that there has been a fraud or whatever. That would bring you back up to paragraph B, right? Completion of the investigation. No determination or not enough evidence to support the allegation, something like that, and then that data is public except the exceptions that are listed
If they've
there.
made a determination.
Yeah, they've made a determination, but in paragraph D, where you've got an investigation, maybe you're suggesting disclose the nature of it, but they're not closing it. It's just kind of on hold indefinitely. I'm a little bit concerned about just being on hold indefinitely. I mean, there is language in the proposed statute already for final reports to be issued. I'm sorry, in the OLA statute, they've got the language about final reports. But how do we deal with, are you suggesting that there should be a public disclosure that so-and-so organization has been accused of fraud, but we don't have time to investigate it further, but we're just going to put it out there that we've received it and this is the accusation and that's that?
Well, if they're not gonna act on it, why not?
Well-
And that's what we're talking about in 222.1. Data relating, because I think the public deserves to know if there's nonprofits or entities or any contractors with any government money, it doesn't have to be nonprofits, companies or whatever, that they're not, and there are allegations. Just like with things, Mr. Chairman, we do know that in public employment for law enforcement officers, we know how many complaints they get. We are then told Officer Neumeister got 15 complaints over the last 8 years. 3 of them, he was disciplined. The other ones, we don't have no idea. We know the existence, we know the status, but we know about that officer. I can see
You're
something.
presaging our conversation on Wednesday, so
So,
you can come back for our Brady
But I use
discussion.
that as an example of how this could be with this dynamic that we're talking about. We'll know the existence, we can know the status, we can know the nature of those cases that are in 222. Your point is probably right here. If there is a determination of something, it will become eventually public, up, from the further part. But it's that 222, page 2, line 22, where I have some concerns about.
All right, thank you, Mr.
Mr. Chairman, when the legislative auditor was interaction with myself and Matt 2 years ago, we had a Zoom meeting because we were still under COVID, to some extent, I think, or whatever it was. There were hundreds of allegations. This is not no 10, no 15. And if the Inspector General is going to get a lot, particularly it's with the Inspector General, who's the panacea to do against fraud and waste and all that, we should be able to know at least those ones that they may not work on, or they may just differ with, or whatever. That's why I think it's important for page 2, line 22 language to be opened up a little bit more so we can get more information.
So if you had your way, Mr. Neumeister, line 2.22 after the comma, after the first comma, you would insert the word nature, comma. Is that
Nature
right?
And the entity.
Well, you'd have to have the entity identified just so that you know there's something in existence in the first place. But, okay, I see what you're saying.
Definitely don't want conclusion. I don't know about entity, nature. I mean, I think we should be discussing it along with the OLA. Yeah. I don't know what you were working on. Wasn't this?
Okay, I'm just trying to get clarity on what your preferred outcome is. We don't have an amendment formally before us yet, and we're not going to, I want to make sure we get all our testimony and discussion, then we'll put this in front of us, and we'll see what our authors wish to do. But thank you, Mr. Neumeister.
Thank you, Mr. Chairman. Much obliged to you for your time.
All right. Okay, those are the only testifiers we had that had signed up for us ahead of time. So why don't we have the A-19 amendment formally placed before the committee, and then we can have a conversation about what we'd like to do with it. Senator Clark?
Chair Latz, I move the A-19 amendment.
Senator Clark moves adoption of the A-19 amendment. All right, let's have some further conversation. Senator Gustafson, Senator Cruin, what are your thoughts based on the testimony that we've heard?
Thank you, Mr. Chair. First, I'd like to start out by just saying, appreciate the discussion, I appreciate the testimony. I personally am not unsympathetic to the issues that were raised by Min OG, is that what we decided on? Close enough. Okay. Minnesotans for Open Government, and Mr. Neumeister. And to reiterate what I said in the opening comments, the caution here, why we borrowed from the OLA statute was because we didn't have an inspector general here. We didn't have somebody that is actually administering the program right now that might have some practical examples about why disclosure of some of these documents would not get at the intent of transparency and would in fact could be punitive and all these examples that we've been talking about. And we knew, or at least we thought with the OLA statute, the balance that we all seek, that we all want here, had been vetted and negotiated with somebody who is administering it. Now, if that never came to Judiciary Committee, then that's something that maybe we need to take a look at. But we know that balance is the key. And when it comes to lines 218 to 225, could it be expanded a little bit? I think it probably could be, but I still think it's prudent to start with the OLA model and work backwards from there if a change should be made to abandon investigations. We could tackle that with both the OLA statute and the OIG statute at a future date, and in that instant, make sure that it comes to Judiciary if that discussion didn't happen here. That was before my time, I believe. So that's kind of why we set it up the way we did. You know, as far as to Senator Limmer's point on the status of investigations, I don't think we need a prescriptive announcement. I don't think we need to add that to the bill. We just need it to be determined upon request, which is in here. I think that's good enough on that issue. So really, you know, when it comes to lines 2.22, you know, data relating to the investigation's existence, status, and disposition, could we add nature? Maybe that's a committee discussion. We definitely don't want to add conclusion there, because from what we're understanding is there isn't going to be a conclusion in those situations, or it would revert back up to a closed investigation. To try to think through the implications of adding the word nature, you know, I wouldn't speak for Senator Gustafson. That's a conversation worth having anyway, on what the implications of that would be. But I think I do want transparency in this office. I also don't want the just the simple fact of making an allegation on somebody that doesn't rise to the level of an investigation to a conclusion to be used against somebody either. And that is a balance that we need to grapple with. And again, that's why we started with the OLA model, because it had been grappled with, negotiated. And if we need to do further work on that, I think I'm certainly open to doing that work. So anyway, Mr. Chair, thank you for the opportunity to respond to that, and very much looking forward to the committee's thoughts on these issues.
Senator Gustafson.
Yeah, Mr. Chair, thank you. I would concur with both Senator Limmer and Senator Cruen. Part of why Ms. Randall's testimony was so important here today is because she was able to explain to us the experiences of that data practice change, because she has worked in the office for so long and understands what it looks like from week to week. I think what we're doing here is trying to apply as many safeguards as possible, because we also want transparency. But we're also mindful that there is no OIG yet set up, and while we don't know how this office is going to be or what it will look like day to day in this office, we want to make sure that we are putting safeguards on there, but also mindful of what they might need and what they might not. I'll also remind everybody that one of the primary differences between an OIG and an OLA is that an OLA is looking more at systematic audits, where an OIG is looking more at providers and recipients. So to Senator Limmer's point, you know, we want to be careful of, you know, having some of this out in public if they find that there hasn't been any wrongdoing and their name is still out there. that could be pretty damaging. So it is a fine line. We're open to having more conversations, but we're sort of, we came to this because it was what we were comfortable with at the time, and there was a precedence for it with the OLA model.
So I think part of the power of this would be the amount of confidence that we have in an inspector general to take a keen and objective eye at, look at the allegations. And if we know the existence, status, and disposition of an investigation without knowing the nature, that we'd be comfortable knowing that if there was something there, it could have been pursued. And the question then is, how do you gain that level of confidence, especially if you're not going to have more transparency about the nature of the allegations? And so, to me, part of that is the structure that we set up. Part of that is the qualifications of the individual who becomes the inspector general. And I think one of the values of having this be a completely independent agency instead of embedded within individual departments of the executive branch is that it is more independent, objective, trustworthy on its own, is less susceptible to agency capture than an IG within DHS or an IG within DPS or whatever the agency is. So I guess I'm trying to articulate from my own understanding how we're going to strike this balance that Senator Limmer cited, so we get the public confidence that we all want and the ability that we all want to investigate it, while not just letting spurious claims get out there publicly that are unfounded or aren't evaluated as founded. But I'm kind of ruminating out loud here.
Mr. Chair,
Senator Kroon.
Mr. Newmeister specifically suggested the word nature in line 2.22. Do we have, is that used, that word used in a similar context anywhere? Do we know exactly what that would implicate, what that would mean if we did go down that road, what exactly that word means? That would be a question I would have about adding it.
Senator Kroon, Ms. Primo has at least identified that if that were added, there would be a couple of other changes that would need to be made in there to make it all work together. But to your specific question, let's see if Ms. Primo has an answer.
Mr. Chair and members, that word is used in several places in Chapter 13, and I'm just sort of control finding it here and there. But in the licensing data statute, which is 13 point, the welfare data statute, 13.46, there is some reference to the general nature of the complaint or allegations. It's more so coupled with other qualifying pieces. The nature of the basis for the denial, I think that's considered public data somewhere in 13.46 subdivision 4 as well. So there's some precedent for that, but with additional language around it.
I don't know, Mr.
Senator
Chair.
Kroon.
I don't know how you would use the word nature there without getting into the details of the complaint, I guess. And that's kind of what we're talking about here. And so if there's a way to expand line 2.22 with a different word, I don't know. And if we were gonna, would we also, would it make more sense to do it in this bill now, or would it make more sense to look at it, say, a year from now or 2 years from now, in context with the OLA statute as well? and have that conversation in judiciary then. So it's a question of where you start. Do you start where it is now and work towards that, or put it in there and work back from it? So that's the policy consideration.
Mr. Chair,
Senator Gustafson.
instead of nature, could you offer what category it falls under? So data relating to the investigation's existence, whether it is being looked at as civil or criminal, the status and the disposition, or does that make it worse?
Senator Gustafson, my guess is they wouldn't know whether it's civil or criminal until an investigation is looked at to see what the factual credibility of the factual allegations are, and then whether they would violate a civil or criminal statute. Might be hard to categorize it up front. Counsel suggested maybe the word basis. But even then, I mean, if the basis is fraud, for example, then you've got an allegation out there publicly that there was an allegation of fraud against a particular entity. That was, investigation of which was paused indefinitely for lack of resources or lack of other supporting documentation or whatever the case is. So, I mean, I'd love to hear input from any others, members of the committee here as well, but if we come up with some language here, great. We're going to conclude this by 2:30 today either way, because the bill needs to move forward if it's going to make the legislative process. But if we do that, I at least would want to have, rather than sort of one of us promises to bring the issue back before the committee in a year or two, I'd be inclined to put in some language that asks the OLA and the new OIG to submit a report on this topic for our consideration, so we have some additional analysis and basis for reviewing this, and we've already got it in place to look at, to make sure we're prompted to do so. And we could even have the OLA do it by next, I don't know, whatever, pick a date in time for us to consider it next legislative session. The OIG within a year of the office being established and up and running or something like that. And certainly the conversation could continue after this committee hearing today. And if there were further discussion or revelation on it, we could always bring it back. This is like a chief author's worst nightmare to hear a chair say, but we could always bring it back to this committee to consider any proposed additional language on this topic before it hits the Senate floor. I would not want this discussion to happen on the Senate floor, at least not until after we've had a vetting in committee on it with a recommendation for the full Senate to consider. Mr. Newmeister, you had something to add? Come on forward.
Mr. Chairman, members of the committee, I'm aware that some states like Florida and some others, they use the word general description. Is that the same as nature? I don't know. So they do a general description of the types of allegation.
Thank you, Mr. Newmeister. Senator Limmer. Wasn't sure if your eyebrows raised meant you're commiserating with me or if you actually wanted to say something.
If I can quote a former president, I feel your pain, Mr. Chairman. I guess I'm looking for your intent today. We've run into a few items, a few subjects that probably should have should have had maybe prior to this a more thorough discussion, as we've gotten off on a few tangents, but they're important tangents, I think, to include. At this short time factor, I'm not sure if we can do it real justice. You had mentioned that you wanted to move the bill out with the opportunity to revisit. We could pull it up again, but would you want to lay the bill on the table to allow for further discussion to happen and then come back to the committee with perhaps some refinement? I'd be more than willing to help the authors and outside people. Outside people is not the right word, citizen participation of the ones who came here to perhaps work on a few subjects and then reconsider or pull the bill back up. Option's yours, but where would you like to go with this? Because I'm not sure if in the next 32 minutes we can really unravel all of this.
Now here, Senator Limmer, here's what my thought. We got a couple of options. We either get done what we can in 30 minutes and just send it on its way. We lay it on the table and bring it back up after there's been some further conversations and we set more time aside to thresh this out in committee. We move it on with the promise that it will come back to us at the end of the process for additional consideration. We did that last year. When did we pass the cannabis bill? It went through this committee in 2023. I think we were the first or the second stop, and we moved it on with the commitment from the chief author that before it hit the floor, it would come back to this committee, because there was stuff we just couldn't do justice to. Or one other way to do this, which I think is the way I'm inclined right now, I'd like your input, Mr. Minority Lead, is to move the bill forward, but with the understanding that this issue here will continue to receive some vetting informally, and that we can bring the issue back in front of this committee, I think, without having the formal bill in front of us in the nature of an informational hearing for us to review and vet it. And without formally passing it, we could informally recommend language that could then be caught up to the bill wherever else it is in the stage, and as long as it's adopted in whole at whatever other committee would take it up, or an agreement to adopt it in whole on the floor. That way we could do the work on it, and our thoughts then could catch up to the language in the bill as it's being moved through the process. And I think that's what I'm inclined to do. So it gives the bill the opportunity to make it through the process in time, because it's got a whole bunch of stops, so it still preserves our opportunity to resolve this if we don't feel it's resolved today. Senator Gustafson, what do you think?
Yeah, thank you, Mr. Chair. If it does help with the decision, this will go, it started at state local gov, and it will go back to state local gov before it moves to the floor. So there would be time to vet further language and then adopt it there. But if the committee would like us to come back on just this one point before it goes to the floor, we're open to whatever makes people feel comfortable, or we can solve it in 30 minutes. Up to you.
So I think I'd be inclined to move it out of committee today and see where the conversations go, and if there's time before it hits the floor, bring the bill formally back here, and if there's not, we can still have a hearing and identify language that should be added to the bill wherever it's in process. Senator Limmer, what do you think about that?
Mr. Chair, would that be passing without recommendation then?
That would be fine too. I think it's more important. I think it's better if we pass the bill with recommendation, because there's more to the bill than just this, obviously. And a lot of the bill is within our jurisdiction, not just the data practices part of
Mr.
it.
Chair,
Senator Limmer.
before we consider the motion, could we get an itemized list of what issues have been raised today that we can process? We certainly had the one notice about the word nature, or what was the alternative, general description. That'd be one thing to consider. The second thing was, starting on line 2.18, we had the discussion of whether or not the public would ever know if the Inspector General's office was no longer actively pursuing an investigation, and does that require some kind of notice? I'm trying to think on the top of my head what other subjects might have been on that list that we're trying to get clarification on.
Well, I think those are two right there. I see the chief author is making notes of that, so we'll certainly identify those two. I know Senator Westrom had a comment, I think, to make as well, and then I was going to ask the committee if there's anything beyond this particular topic within the bill that we want to talk about.
Oh, Mr. Chair.
As well, Senator Limmer.
One
before
other
Senator
thing,
Westrom.
there was a reference on lines 2.11 under the term completion of the investigation. Does that term mean finding of an accusation or coming to some conclusion of an investigation? Does that word, that series of words, completion of the investigation, mean that? And if it's not written here, should there be some reference to that?
Let's ask Ms. Primo if there's anything more to what that means than the 4 words on line 2.11. Ms. Primo?
Mr. Chair and members, I think it captures the role of the OIG coming to an end. Under the bill, I believe in section 10, there is a requirement, it's on page 7, that the Inspector General must issue public reports detailing completed audits and investigations. So at the end of that completed investigation, there would be some sort of report and then potentially also referrals at that stage or perhaps earlier.
So Ms. Primo, to make sure there's that cross-reference, theoretically on line 2.11 after investigation, we could insert under section 15D.06 or something to that effect. That would be completion of the investigation. Ms. Primo?
Mr. Chair, if the committee feels that that may be clearer, the language at 2.10 to 2.11 states that the data is related to an investigation conducted, and actually that should say under this chapter. So that would be a technical amendment, changing section to chapter, so it's clear that the provisions in this newly created chapter 15D would apply and inform this provision.
So Ms. Primo, if section were changed to chapter, you think that pulls in 15D.06 in section 10 of the bill?
Mr. Chair and members, I believe that that would be adequate.
Senator Limmer, would you like to move that technical change just while we're on the topic here on line 2.10? Delete section, insert chapter in its place.
Mr. Chair, I'd like to ask the individuals from the former Minkoji group if they think that that hits the nail on the head on this area.
Mr. Ealing from the organization formerly known as Minkoji.
Thank you, Mr.
Do you have a symbol now that we can use?
Symbol is pending. Thank you, Mr. Chairman. Senator Limmer, I was reading something while you were speaking at the tail end of your conversation there, Senator Limmer. Can you repeat the question? I missed it.
Well, there's Mr. Chair, there's
Senator Limmer.
an amendment that we're discussing on lines 2.11 to make a reference to a pending statute found on in the bill 7.9, the reference of statute 15D.06, that there would be an announcement found in that section allowing for a description more of what the completion of the investigation would mean.
Senator Limmer, that is a possibility. What I was thinking about during the previous discussion here was other ways to address that too. If you look down at 2.22, You could also include language such as something similar to what Mr. Newmeister had talked about, a brief description of the allegations and the reason for the non-completion of the investigation could be another way to deal with that. And I know the public nature of uncompleted allegations has been the subject of a lot of discussion here today. Our thinking on why that's important is that, again, it goes back to the Marv Davidov example I was talking about. So the fact that there will be public announcements about who was investigated is important for people who were investigated. Because again, this is one of the government's most powerful tools, is to investigate individuals and entities. And the data in this abandoned category would be private or non-public. So the entity would then have public notice that they were investigated. They could then request the data underlying the investigations. And if they wanted to go with public then and say, look, we are innocent, we were investigated for faulty reasons, they would have access to that and they would have notice to look into that data.
Okay, I'm going to bring us back not to the abandoned category, but specifically to the completed investigation category. The only question right now that I'm posing for the committee is, do we need to make any change in the language on line 2.10 and 2.11 so that completion of the investigation is clearly referring to the completed audit, investigation, or corrective action taken in section 10 of the bill? And council has suggested that on line 2.10, the word section be replaced with the word chapter to link in the completion definition. Mr. Ealing, do you think chapter will be satisfactory to close that loop?
Mr. Chairman, sorry to get off on the tangent. To your original specific question, yes, chapter would be the proper technical change there to make. That would be sufficient, yes.
Senator Limmer, would you like to move the
Yes.
amendment to the A19
Yes,
amendment?
Mr. Chair, I'll move the amendment on 2.11 as described by council.
Senator Limmer moves at line 2.10, the word section be deleted, and in its place insert the word chapter. Any further discussion? All those in favor say aye. Aye. Opposed? Motion prevails. That amendment is adopted. Members, we're not going to, let me ask if there are any other topics in the A19 amendment, Senator Limmer, and then we're going to turn to Senator Westerman and Senator Howe as well.
Thank you, Mr. Chair. I noticed on the third page of the A19 amendment, at the bottom of the page, lines 3, 24, and 25, there's an exception that's recognizing the Department of Corrections. And I was hoping someone could explain what that means, as well as why would there be an exception for the Department of Corrections?
Commissioner Schnell, I understand you're present. Oh, there, you were hiding in my line of sight behind Senator Crew, and I didn't see you there.
I saw him.
But you moved the county attorney's representative out of the way there so you could come forward. No metaphors go any further than that. Go ahead, Commissioner.
Thank you, Mr. Chair. Paul Schnell from the Department of Corrections. To your question, Senator Limmer, the core reason why it's removed and why we had talked with the authors is the fact that the OIG at the DOC is really fundamentally different. Number one, it was not it's not a statutorily created office, whereas the others at least have some grounding in Minnesota law. The OIG at the Department of Corrections really focuses on a number of core kind of things that are really largely internally focused. First and foremost is that they do internal investigations at the Office of Professional Accountability. Second, they do some internal audit functions. And those, while those internal audits are financial in nature, the internal audits are largely program-related and internal. For instance, they recently completed one related to on-call within the agency, but it's focused on internal operations. We put it under this office. In the past, those functions were done in finance. We moved those functions to under this title of Inspector General because we desired to make sure that there was separation between finance and the function of internal audits. The other core function is is related to the audits of ADA accommodations within the agency. This has been a large area of focus, as we've talked about in committee before. There was a Department of Justice consent decree related to ADA accommodations. So that audit function was placed under there. And then finally, and one of the other large areas of business that gets done is the licensing of county jails and the inspection of county jails across the state. So as you can see, the difference in the work, in retrospect, we probably should not have used the title Inspector General for this role. But it seemed to encompass just the broad range of work, and that's why we titled it in that manner. But really, I think that's the core difference between the focus here on fraud and waste versus the internal focus of the current Inspector General's office within the DOC.
Commissioner Schnell, I understand it's your intent, should this become law, to change the name of that office within the DOC?
Mr. Chair, that's correct. In speaking with the authors, that was suggested to be the best course of action going forward.
Sounds like a good idea.
Mr. Chair,
Senator Limmer.
Mr. Chair, if this language remains in the amendment and the amendment gets adopted, does that prohibit a future Inspector General from investigating anything in the Department of Corrections?
Commissioner Schnell,
It
you
is
have an
written as
opinion
an
on that?
exception.
Mr. Chair, I think the intent, as I understood it, was the removal of the OIG from the DOC from the list of transferred positions and so forth. Not that, certainly that, not that the OIG couldn't conduct investigations where it deemed appropriate.
And, Mr. Chair,
Senator Limmer.
Commissioner Schnell, you made reference to a consent decree by what department in federal government, was it?
Commissioners.
Mr. Chair, Senator Limmer, yes, that was the Department of Justice. It was related to ADA accommodations for special education
Could you do
students.
me a favor,
Senator
Commissioner, and send me a site or a reference for that consent decree?
Yes, I will.
Thank you. Appreciate that. I'm done.
Senator Westrom. Then Senator Howe.
Mr. Chair, just two questions on your earlier comment about moving the bill and what would be the best, most desirable path. And my first question would be to the author or to you, Mr. Chair, how many other committee stops do you anticipate having specifically or in an approximate?
Senator Gustafson.
Thank you, Mr. Chair. Thank you, Senator Westrom. I know we had planned to go to Ed Finance this week. We'll also need to go to Health and Human Services, possibly the Rules Committee, Labor Committee, back to State Local Gov, possibly Commerce, possibly Human Services Committee. So we'll be everywhere.
Okay. And so, Mr. Chair,
Senator Westrom.
I guess as we discuss coming back here, would be my thought that at least having an assurance that it'll come back for that topic, I think would be a better process than maybe it's a bit loosey-goosey to kind of say, well, we'll see if it gets worked on, but there's really no formal way for the committee to get it back to just know that there's a resolution. So that'd just be my comment or thought, that I think would be better to plan on that among the committee stops, and if rules is one of them, it probably could even make it after deadline, it sounds like, if that was people's desire, but just food for thought.
Thank you, Senator Westrom. Senator Howe.
Thank you, Mr. Chair. And I think, getting back to the item that Senator Limmer brought up on 3.24 to 3.25, I think a much better approach, if that's what we're going to do, is delete this off of the amendment and actually delete the item in the original bill at 2.1, which would then actually get rid of the transfer of the position, rather than adding that language here on. I think that's a more efficient, effective way to get that done, and would be the intent of what we're trying to do.
Senator Howe, 2.1 is existing statute.
That's,
It's a list relating to agency head salaries.
well, I
Section
take
2 of
that
the
back.
bill
Then
only deals
I
with
guess,
agency
I
salaries.
was just looking real quickly for the list of where is there a list of existing OIG positions that are gonna get transferred then? Or why would we make this comment at all if there's actually no item anywhere that's actually listing the OIG positions that are moving?
Mr. Backus.
Mr. Chair and Senator Howe, I think the provision you'd be looking for is on page 8, lines 26 to 27 or 28. It just says, "All officers and employees employed in an office of Inspector General for a state agency." So it's kind of just a general transfer there.
So, Mr. Chair,
Senator Howe.
if they're gonna change the name of the office, then why would we actually make an exception?
Mr. Chair,
Senator Croon.
because to Senator Howe's point, the office is still named that, and I'm not sure that because it's not a statutorily created office, whether it would be appropriate for us to dictate the internal name of that position within Department of Corrections. But I think the intent is, once it's passed, for the Department of Corrections to do that on its own with its own decision about that. But I don't know if there's another legal reason why we couldn't just force or by law the Department of Corrections to change its name, but my recollection is there's a legal reason why we shouldn't be doing that in this bill.
Commissioner Schnell.
Mr. Chair, it's a great question. One of the things, just in the spirit of transparency, the last thing that we wanted to do was change the name of this office while this bill was being discussed. So that was the number one concern, just to make sure that there was complete transparency, that we weren't trying to avoid being brought into this bill. And so I think the intent here and the discussions we had with authors were really to try to make sure it was crystal clear that we were not trying to avoid it, that it was fundamentally different.
Senator Croon, is it your view then that the language in the A9 amendment on lines 3.24 to 25 are satisfactory for meeting the needs at this time?
Mr. Chair, my position is that the duties and responsibilities from what the Department of Corrections currently calls their Inspector General are not the functions that we anticipate this Office of Attorney General undertaking. The important thing from my perspective is that there's nothing in the bill that limits the jurisdiction of this new OIG to do anything that it's allowed to do under the bill within the Department of Corrections. There's unfettered access, there's no carve-out. The Department of Correction is still going to be subject to this bill. It's just simply the existing employee that they call an Inspector General doesn't perform the functions that this office is going to do. And so we just wanted to make it clear that that person's not going to get sucked into this new OIG office. And then we anticipate the Department of Corrections calling this position something else. Whether we want to do that in this bill and say you shall call it something else and therefore this becomes not necessary, I guess I personally don't have a problem doing that. I just not sure if that's the best way to do it. I think this gets at what we're trying to do.
Senator Gustafson.
Thank you, Mr. Chair, and council will maybe have to help me with this, but I'm pretty sure if we put it in, if we change their name in this bill, then we are maybe a little too close to legislative authority over that position. I might be wrong, but I think there was a specific reason why we couldn't rename that position in this bill.
Mr. Chair,
Senator Howe.
you know, I didn't, I really think what happened was by putting it in, language in here, it actually did suck them into the bill, which most of us really wouldn't identified, I guess. Well, no, I mean, the discussion came up because it came here, otherwise I wouldn't have really noticed it. So it did kind of raise the question, otherwise it would have never came up, I guess is
Senator Howe,
my
are you
point.
satisfied with the answer now, so you no longer need any
You know,
changes?
I still have a problem with that language, but I'm good. The other question I have then, Mr. Chair, is the exceptions on 1010 through 1019. I take it those exceptions are there because of the Department of Human Services, because the federal law requires that to be embedded, or you can't just embed them from the office of the IG? That would be my question. Can they be under the Office of IG and then embedded into the Department of Corrections to fulfill the federal requirement, if there is one?
Mr. Chair.
Senator Howe, those are not Department of Corrections provisions.
No, they're
1010
Department of
is
Human Services. Yes.
Senator Kroon.
Thank you, Mr. Chair, and thank you, Senator Howe. The reason that that exception for the Department of Human Services is in there is because that position is required to be embedded under federal regulation. Again, as the same, though, applies as to our previous discussion about the Department of Corrections, in that there's no limitation for this new Office of Inspector General to do work within the Department of Human Services. So the new office will have jurisdiction, will be able to do investigations within the Department of Human Services, but this particular position needs to stay embedded to comply with federal regulations. Now, the overall structure of whether or not the new Office of Inspector General can have embedded deputy or assistant IGs, we've purposefully created flexibility for the new Inspector General to make that determination. There's nothing in the bill that requires it, and there's nothing in the bill that prevents it. So if the Inspector General decides as they are starting their work and their org structure that that's the model that they want for certain agencies or with all agencies, they have the flexibility to do that within this bill, but they're not required to do it.
Senator Howe.
Thank you, Mr. Chair. I guess that's my question, though, is that to meet that federal requirement for the Department of Human Services, could these OIGs be sucked into, if you want to call it that, put into the Office of IG and then embedded in and meet the federal requirement? So they are embedded, but they are still under the Office of the OIG. But then you embed them, they're required to meet this, so you embed them into the Human
Senator
Services.
Thank you, Mr. Chair, and thank you, Senator Howe. The specific exceptions as laid out in 10.12 to 10.18, these are not functions that we envision our Office of the Inspector General, the new Office of Inspector General, to be handling. These are narrow provisions that federal regulations requires an embedded Inspector General look into. So how we envision this bill operating is that Inspector General will stay embedded in the Department of Human Services, doing those functions as set forth in this statute. The new Office of Inspector General will have the jurisdiction to conduct, its broad range of investigations within the Department of Human Services, if that's where it leads. And the OIG could embed a deputy or assistant inspector general into the Department of Human Services, but I don't think they would be doing these specific job duties. Those are kind of specific to that federal regulation. But certainly they could embed somebody in there to look for waste, fraud, and abuse, or they could not embed them, and the flexibility is built into the statute.
Thank you, Mr.
Any other members of the committee have any discussion, comments, or suggestions regarding the A19 amendment as amended? I'm not seeing any further comments from either of our authors at the testifier table before we consider adoption of the A19 amendment to the bill. Not seeing any comments. Senator Clark has moved that the A19 amendment as amended be adopted. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Members, we now have before us the Senate File 856 as amended. Is there any further discussion about the entire bill that is before us? I will, as a matter of course, indicate, as I already have, that the conversation that we had with Minnesotans for Open Government and others relating to those provisions for abandoned investigations will be considered further by this committee, formally or informally. We'll try to do it formally if we have the time to bring the bill back before us. But if not, either way, we will have a hearing and try to resolve that one way or the other. We'll make a decision as a committee how to proceed on that. Fair enough, Senator Gustafson?
Yes, thank you, Mr. Chair.
Senator Cronin?
Yes, thanks, Mr. Chair.
Any further discussion about Senate File 856 as amended? Senator Cronin, do you have a motion for the committee?
Yes, Mr. Chair, I'd like to move that the bill as amended pass committee and be referred to the Committee on Education Finance.
Senator Cronin moves that Senate File number 856 as amended be recommended to pass and be re-referred to the Senate Committee on Education Finance. Senator Limmer.
Mr. Chair, I'm a little uncomfortable with the progress of this bill. I know we've had a good discussion of it, but at least for the record, I'd like to alter the motion of no recommendation rather than to pass. The bill is not complete in my mind, and I would like to at least have that on record.
So Senator Limmer moves to amend the motion to change recommended to pass to without recommendation. Senator Cronin, it's your motion. What is your position on that?
Thank you, Mr. Chair. I think it should be recommended to pass. And the reason for that is because this is a very, it's an important piece that we've been having a discussion on today, but it's within the context of a much broader bill that is important. And the commitment that we've made to bring this issue back to the committee on a formal or informal basis, and given the fact that we're working very well with Minnesotans for Open Government and Mr. Neumeister, I don't think that's a sufficient basis to have the bill pass with no recommendation. So I think to keep this bill moving and to signify the significance of this bill and the importance of it to Minnesota, I think that the motion should remain to pass and refer to Education Finance.
Senator Limmer, in light of the motion's author, how do you wish to proceed with your move to amend the motion?
I'll withdraw the motion.
Senator Limmer withdraws his motion to amend the motion. Is there any further discussion? Senator Cronin renews his motion that Senate File number 856 as amended be recommended to pass and be re-referred to the Senate Committee on Education Finance. All those in favor say aye. Aye. All those opposed? Motion prevails. Members, thank you for the excellent discussion and work of the committee today.
Thank you.
We are returning to committee on Wednesday, February 26th at 12:30 p.m. in this room. We will be taking up a number of Brady Giglio bills at that time for conversation only, not for action on any of the bills. Thank you. We are adjourned.